Employer Exchange by Monarch Law. Our goal is to help small business owners improve their workplaces by sharing personal stories and discussing relevant legal issues. Most episodes, you'll hear from a local business owner with an employment story to share, and sometimes there'll be horror stories. Special episode, members of the Monarch Law team are here to introduce themselves and share some stories of their own. I hope you enjoy and find this helpful. And to start us off.
Good morning, everybody. Dan Seiden with Monarch Law. Tony and I are the partners and owners of the firm. Great to be here.
My name is Alana Ferrigno. I'm an associate attorney here at Monarch Law, and I'm excited to be here.
Cool. I'll go next. My name is Laura. I'm the real estate paralegal at Monarch Law and excited to have a chat.
I am the litigation paralegal at Monarch Law, and my name is Paige, and I'm also excited to be here.
Great. And I'm Tony Interlandi. Our goal, again, like I said, to get these stories out there, help small business owners, help them make better workplaces for their employees, and let the employees kind of understand what the law is in situations that they may find themselves in. So for today, we'll go talk about some of our own stories and maybe talk about some of the law that was involved. Or is Dan, do you have any stories from back in the day at maybe at another law firm or maybe even before you got into the law? Anything that stands out to you from the...
I've never been one to suffer any significant situation in an employment setting. Never had to file any claims or anything like that. And, definitely consider myself fortunate. I did have a scenario, though, and this brings us back to the days of COVID. So this was pre-Monarch Law. And COVID was kind of the Wild West. It was a scenario where the world didn't really know what was happening and people didn't know how to react to things. And so things were, as I said, up in the air. And while it seemed as if everyone was taking precautions and being overly cautious, there was a scenario where a member of the workplace had tested positive for COVID. And this is probably a month into the COVID pandemic. And how do we react to that? I mean, all of a sudden, I had a newborn son at home who was 3-4 months old at that time. And now I have somebody coming to the office with a situation where they have already knowingly tested positive for COVID. How do you respond to that? How do you react? And at the time, there wasn't any real answer to that. It was scary on my part. Knowing what I know now, there's probably not much that could have been done in that setting, whether you're an employee or an employer. Going home and working from home, I think, was probably the right answer, and that ended up being what happened and what I did. So quarantined for 2 weeks in my basement away from my family and my newborn son at that point. And, that's just something that jumps out to me as far as how we react and how we handle things in the workplace with regard to sickness. And I think that it's an evolving area where I think employees are more apt to stay home. Employers are more apt to allow employees to stay home and work from home in the event of a sickness, especially such a communicable disease as or virus, I should say, as coronavirus. So it's just an odd situation that I had to deal with. And other than having to work from home and be away from my family, it thankfully didn't lead to any type of litigation or case or claim or anything like that. But it's something that I could certainly see and to have certainly fielded calls from other individuals about how COVID has been handled. So that's off the top of my head, that's something that I remember going through. And thankfully it wasn't much more than that.
Represent employers as well as employees. So does Dan. And back in those early days of COVID, had a lot of calls about unemployment appeals relating to COVID. So whether it was people being furloughed or let go, or quitting because the employer wasn't taking necessary safety precautions, here we saw a big spike in the number of calls we got and the cases we received in terms of representing folks, whether they were on. There was a lot going on with that. But let's back out of COVID. Kick it over to Paige. Anything that stands out to you in your life of working so far?
Man, I have some stories, but in terms of stuff that brings in some legal questions, when I decided to leave my previous job, I obviously, cleaned out my desk in anticipation that I was going to give my notice. I didn't plan to give the letter until after I left. I was going to do it by mail because I just wasn't sure what kind of reaction I was going to get, and didn't feel comfortable handing it in. So, I cleaned up my desk and took my stuff with me and gave my notice later. And I had a coworker who was still working there. And my old boss, took them aside the following day after he gotten my resignation notice and said, Paige walked out with her stuff yesterday. She technically took personal property from this office, like my pillow, my blanket. Really, he was like, you should let her know. Like, she's lucky I'm not filing charges against her.
Wow.
Yeah, there's that. That same employer also had an issue for my time, part-time employees into the Department of Labor because we're being forced to take a 50-minute unpaid break and a 30-minute unpaid or an hour unpaid break. And I'm not sure about the legal aspects of that, but I remember that being a big thing before I got there, that there was and then in retaliation for doing so, the entire part-time staff got overturned. They got fired.
Wow.
Yeah.
So those are two good issues, right? Like the first is mandatory break periods in Connecticut. You work a normal full-time workday, you're entitled to at least a half-hour rest period or meal break. And then the other is really not so much in a legal sense, but some company may have a policy where we would like 2 weeks notice of, that you're going to be leaving us, right? But so what? What have you give 1 day's notice? What can they really do to you? It's just a policy. So we get that a lot where people will call. I know Dan has probably had some of these where the person wants to quit, but they don't want to give the 30 days notice per the policy. And we've had some back and forth with clients on that.
Yeah.
Dan, any thoughts on that before we kick it over to Alana?
Just going to chime in. I mean, it's kind of what's good for the goose is good for the gander syndrome sometimes, where employers like to fall back and say, hey, we have an at-will employment agreement. I can let you go anytime I want. I don't have to give you notice. On the flip side, they say, hey, employee, we've got this written policy that says you have to give us X amount of time. But technically, as an at-will employee, the employee owes the employer nothing as far as a notice provision. I think if there's a severance or other options that an employer can do to make it more enforceable or at least tied to something. But otherwise, it's at will state. Employee has the right to leave employment with or without notice. And that's my take on it. That's kind of the thought I'm giving people when they tell me that they have, I'm required to give 2 weeks notice or I'm required to give 30 days notice. Well, that's the nice thing to do, and that may be the written policy, but that's your employer's policy.
Does that have anything to do with any PTO you want to get paid out on? If you just quit, they don't have to do that, or does that matter?
Dan?
That's exactly what I was talking about. So you can make it a scenario where, hey, we'll pay you your PTO, but you've got to give us 2 weeks notice. And if you don't, we're not paying your PTO. And if that's a written policy, that's an enforceable policy in the state of Connecticut.
Yeah, you're not owed it.
No legal obligation to pay out PTO. Company has a written policy, right? And if it does, then it has to pay it out. But if it doesn't, then it's kind of up to the employer. Now, if the employer, and Dan and I were going back and forth on this recently, if the employer has paid out PTO, right, despite the absence of a policy, now that creates, agreement to do that, and the Department of Labor could look into that. Another thing, just to get back to the notice period too, something that an employer can do is in an offer letter, or even maybe there's some kind of agreement at the front end of the employment relationship, say, I'm giving you a $500 sign-on bonus, and lay out some of the terms, and in connection with that, or connection with the employment relationship, we have, a 30-day policy in terms of separation if you're going to give us notice of resignation. And if you breach it, then you have to pay that bonus back. All right. So that gives the employer a little bit of teeth behind the policy, and makes you think twice. Like, oh, I know I'm going to have to pay $500. That's fine. I want out of here. So here's $500, and I'm going to give you 1 day's notice or 0 days notice. But that's a way to combat that. But that's an enduring that. Alana, how about you? I know, you have a history with a family-run business. You've had other jobs, some really interesting things. Why don't you give us an idea of?
Yeah. I guess one thing that comes to mind that wasn't really involved in my family business. I was actually waitressing at a restaurant in like Lower Connecticut. It was an okay experience when I started, and then kind of as I continued working there, I kind of had weird interactions with one of my managers, and then he kind of started sending me like super inappropriate text messages, and it was just like getting increasingly weird and creepy. And it was definitely sexual harassment, and it just got to a point where it was like not just the manager, but like also a lot of the staff there was kind of engaging in the same kind of issue, and there was like no one really doing anything about it. And so it got to a point where I just quit because I wasn't comfortable being there any longer, and it kind of coincided when COVID was just starting, so it was kind of an easy exit for me to leave. But in hindsight, I kind of wish I had done something more about it, other than having to just leave. But that's one thing that comes to my mind that I feel like sometimes we kind of hear a lot about from sometimes people working in like the service industry. It seems to be like a common issue for a lot of women.
Yes,
So yeah.
I absolutely agree. I definitely had a similar experience working as when I was in college, working retail. Definitely. Not necessarily managers, but coworkers. I think a lot of the time there was one-off comments made, maybe not like rising to the level of like sexual harassment, but definitely making people uncomfortable in a way I think that 10 years ago was maybe more socially acceptable. We didn't know yet that it was time to or we could raise grievances or complaints about that behavior at the time.
Yeah, it's a scary thing to be put into, and I can't even imagine what it's like. But having worked here, and hearing about some of the cases that we've handled, and seeing other things like employee handbooks, what do you guys think about how you could have maybe handled that differently back then? Of course, knowing that sometimes if you do complain, it brings more heat on you, right, from the management or whomever. But what do you think? What could you have done to maybe protect your rights?
I think definitely make a complaint at least, at the very least, especially in the case where it's coworkers and it's not when it's a manager or a supervisor. I feel like that's putting you in a tougher position, because then you have to figure out who am I supposed to go to above them, and there's more. You have to go back and look at your policy and figure out where to go from there. And I think the first thing I would have done was go to the handbook and be like, what's the policy? And if to what extent is what's happening against the policy, and now who do I bring it to?
Yeah. Creating a record is really important in these types of cases. And there is, like I said, there will be heat if you complain, but also know that there's also a retaliation claim then that could follow, right? So if they give out an adverse employment action, some kind of random bogus suspension or something like that, or termination, and the real reason is they're upset that you filed that complaint, now you may have a sexual harassment claim as well as a retaliation claim. And I know Dan has had a few claims like that as well.
And I think today's day and age, thankfully, we've seen a shift in this where employers understand, or should understand, that when an employee comes to them with a complaint, whether it's founded or not, that there needs to be something done, and something done to ensure that if that is happening, that they're protecting the employee. So, I know as younger employees and not really knowing where to turn, that may have been what you experienced in prior employment scenarios. I think that the environment has shifted over the last few years, at least. So employers need to be aware of that for sure.
You have a story for us?
Yeah, I hate to echo the previous sentiments, but I had a very similar experience at a previous job. It wasn't an employee, it was a relative of my boss's, and it was just kind of one of those things where it was an unsaid thing that, like, one of the reasons I think I was even hired was because I already knew that this person was like this. So I wish, looking back, that I was kind of a bit more direct with the person as well, and probably talking to my bosses. But yeah, it was an interesting time.
You get calls from employers, no, this person's saying, maybe they think that they're being harassed. That always raises red flags to us. Some employers, it's shocking nowadays that this still happens, but some employers, they don't have any ill will. They're not even trying to like act in a sexual manner, but they're just creepy, right? And maybe they're doing the old back rub or commenting on clothing appropriate, and it may not rise to the level, the state of a sexual harassment type of claim, but there's definitely exposure there. That person may be upset, complain, then something else happens to that person, they get fired, they go talk to an attorney, another attorney might think, yeah, you know what, there's some here. Whether or not they think it's a case they could go to trial and win, they think that there's some settlement value and they're going to get sued. And, I keep referring back to Dan, but we've had cases like that where we defended employers for saying just inappropriate things. And again, it wouldn't go to a trial and we probably wouldn't have lost, but there's cost involved and usually it ends up in a settlement.
It's a reality. I mean, there's dollars and cents that come behind just the claim being brought, the cost of defense and things like that. And, depending on the egregiousness of what happened, you got to take that into consideration and how you're going to approach it. We have that conversation with employers and employees all the time, depending on how we can assist them.
Cost is, the litigation defense and paying for the attorney when you're the employer. And not every employer knows this, but, you can get insurance to cover these types of claims. So employment practices liability insurance, there's going to be a deductible, but if there's a claim made, the insurance company will assign counsel to the employer to defend the case. We don't do that type of work. We pretty much only work with small business owners, small to mid-sized business owners who don't have that insurance, because typically the insurance carrier will not allow the insured to pick its own legal counsel. But Alana, you ever hear of any kind of like insurance? Like, did they have that type of insurance, or you haven't really heard of that?
We don't. I know that we don't have that type of insurance. I think we probably want the ability to pick our own counsel in that case.
Right.
I think that's probably, I know we have a lot of other kind of insurance to try and cover everything we can, but I think for us, we would have wanted to pick our own counsel. So we haven't done that, but we are very aware of what's going on with the staff at all times, just because you got to be vigilant when you have a lot of employees.
I'll mention one other story for me personally. So when I was in high school, middle of high school, I worked at a movie theater. It was called Lowe's Movie Theater, and then it became a Sony. But I loved it because they would cross-train you, and so you had to do the box office, you had to do concessions, and you had to walk around with the little broom and shovel or whatever that thing's called.
The picker-upper.
Picker-upper. And that was great because you get to watch all the movies. So this was like, I could tell you all the movies that were out at that time, but I won't. But what I really loved most was in the concession stand, they taught you how to like upcharge or upsell, whatever it's called. And someone would say, I want a medium soda and a small popcorn. And you'd be like, well, for 85 cents more, you can get the super combo. And then for every super combo. Yeah, and it was great. And so every super combo you sold, I think you got like an extra $1. So you would get $1. So sometimes you get like an extra $50 in your shift, like on a Friday, Saturday night. But one manager, what he would do is if you went, if you just kind of turned your back even, but sometimes if you had to go do something, go get popcorn and bring it back, he would log you out and log himself in to the system. And it was really difficult. You really couldn't tell. I don't even think it said your name. It just had like your cashier register number. Mm-hmm. And so you would keep selling and it would all go, those dollars were going to him. And I had to leave that job because I wound up taking another job, but I didn't realize that till the end. And like a lot of us found out towards like the end of that. And I don't know whatever happened, but that would have been a pretty good, complaint in terms of, it's interesting because it's not like an hourly wage, or it's more in the terms of a bonus where they're kind of taking a bonus from you or a commission. But yeah, knowing what I know now, could have filed a complaint. In those types of cases, just so that people listening or watching know, the law allows for attorney's fees. So maybe it was $50 that I was owed, but if I had an attorney to prosecute that claim and win, he or she could get the court to get an order for attorney's fees and costs for his client or her client. So that's one of my stories. Any final thoughts on kind of the story shared, any of the law related to it? I know we talked about unemployment, kind of that COVID period, which was really scary, sexual harassment, some wage stuff here at the end. Anyone have any other comments?
I mean, the employment scenarios run the gamut. I think we've maybe brushed on the tip of the iceberg here, just on the five of us and the experiences that we've seen. As I mentioned, I'm fortunate enough to not having personally experienced many situations where I felt where I was wronged, but I could go through countless number of things. And, I think that's what we want to do here. And then touch on the law and touch on how people respond to it in the day-to-day world. So I think that this is great. I love hearing the stories and trying to figure out how we react to it in real time, and then how we react to it today in hindsight.
Laura, Alana, any parting words?
Yeah, the only thing I think of is the main lesson I think I've learned working at an employment attorney office, firm, whatever you want to call it, is that it's not illegal for your boss to just be a jerk.
Same.
That's just the way it is. You might have, just have someone who is not very nice, but that's not always illegal.
It isn't a jerk in certain ways, then it might be.
Yeah.
If they're a jerk in a protected class sense.
Yeah.
That's right.
So you probably hear Dan and I, because we probably say that at least once on the phone per day each to potential new clients who think they have a case. And, on the flip side, we kind of use that when we talk to employer clients, right? We don't say that they're being a jerk, but we say, look, we wouldn't do that, or that's probably inappropriate. But you probably don't have any legal exposure because of, you commented on Paige's shoes and her feet look nice or something like weird. I think what I'd like to do is when we close out these shows, I was trying to think of a good way to transition out of here. Just to note, we do have Holly Trumpler here. She's an intern from Southern, and she's behind the board. So I'm going to have her go back so she can kind of close us out on that. But when we kind of interviews, I think what we can do, I'm going to do for this one at least, is an old tip of the cap. So we're going to count it down to 3. We're going to give each other a little tip of the cap, and then that's going to cue Holly to shut us down. And then we'll see how that turns out. And if that's corny, we'll come up with something better, maybe air fists or air high fives for Paige and I, or like to the screen. I'm sure you guys will have a better idea or suggestion after this episode. All right, so let's count it down. Thank you all for listening and watching, and we look forward to our next episode. The next one will be Dan and I, kind of fourth, and talking about some of our experiences in terms of being an employer, business. And then we'll get into our interview mode, and we look forward to that. So with that, 3, 2, 1.